Okay, so what was the last chapter? Last judiciary done. Local self-government done. That's done. Okay, advisory jurisdictions. Okay, okay. Original jurisdiction done. Not done. Original also not done. Original jurisdiction done. Done. Especially by appeal done. क्या हुआ? नहीं, we have taken the same way की class. Okay, jurisdiction of Supreme Court again I am going to tell them. ठीक है? Jurisdiction of the Supreme Court. Jurisdiction of the Supreme Court. First is original jurisdiction. Original jurisdictions. So original means this is already, I think, done. Correct? So till where actually it is complete. I mean, advisory is not done yet. Okay, come back to advisory jurisdiction. Okay. So so advisory jurisdiction, basically it is a legal opinion taken by President of India. From Supreme Court. This is actually advisory jurisdiction. It comes under Article 143. This comes under Article number 143. And this is not available in case of USA Supreme Court. So this is very unique actually to Indian Supreme Court. So one thing not available to USA Supreme Court or Federal Court. Correct? So it is very unique to Indian only Supreme Court. So Indian Supreme Court can give a legal opinion to the President of India. Legal opinion, we are having Attorney General also. Correct? But Attorney General basically gives opinion to the government side. Correct? For example, recently 370 has been removed now. If suppose Supreme Court decision comes opposite, 370 should not be removed. Now President of India can ask the legal opinion from the Supreme Court. So basically, President of India asks legal opinion in 2 matters, only in 2 matters. So what are those 2 matters? First matter is any matter which is related to pre-constitutional treaty. Pre-constitutional treaty or agreement, etc. Correct? Any matter which is related to the pre-constitutional treaty or agreement. When we were covering basically this original jurisdiction, we have covered exceptional things like Supreme Court cannot enter into those matters which are pre-constitutional matters. Correct? So now if any issue or dispute happened regarding pre-constitutional treaty, that means any treaty, any agreement that happened before 1949, correct? During that time, what actually will happen if any dispute? Who will decide this? Because already you have put a bar on the Supreme Court, they cannot interfere, High Court cannot interfere, then who will solve that dispute? So that dispute related legal opinion will be given by the Supreme Court. Correct? So that is a legal opinion. This is an opinion, so it will not be imposed on the government. Government can accept it or reject it. Second matter is matter of public importance. Please mark your attendance, okay? This is pop-up actually, yeah. So matter of public importance. Then this mark of public importance. So this is any matter, it can be political matter also, correct? It can be a social matter also. So for example, when this Ayodhya temple should be there or not, government want to know from the Supreme Court, government can ask to the Supreme Court whether we should build a Ram temple or not. So that is a public important matter. The thing is this here is, in the second case, Supreme Court can deny to give legal opinion. But in first case, it is mandatory for Supreme Court to give legal opinion. This is the difference. In the second case, Supreme Court can deny to give a legal opinion. But in first case, it is a compulsion over the Supreme Court to give a legal opinion. Because we already know if they are not giving legal opinion here only, already they are barred over there, then who will going to solve the issue? So for that purpose, it is mandatory for the Supreme Court to give legal opinion in the case of first, but not in case of second. Because this legal opinion was taken by President also regarding Ayodhya temple. This is a real issue and Supreme Court has denied. It is a political issue. So I will not interfere there. So Supreme Court has denied. Correct? One more thing, whatever the legal opinion, it is binding over the president or not. So it is not binding. Whatever the legal opinion Supreme Court is giving, it is not binding over the president or the government. Correct? The legal opinion will not be binding over the government or the president. Yes, in both cases. It is not binding over the president or government. One thing. Second is, this legal opinion will not be used as a reference in any of the judicial cases. These legal opinions will not be used as a legal reference in any of the court cases. In any of the court cases. Simply meaning is this, for example, in any future, if any case is going on and Supreme Court and any lawyer, they cannot use this. In that, so president has asked an opinion, you have given such opinion, now you are changing your word. So that will not be used. So it will not be the court of record. Next thing is important is, how many Supreme Court judges are involved here to give legal opinion? Only CJI is giving opinion or other judges are also involved? So it will be a constitutional bench. This opinion will be given by a constitutional bench. Constitutional bench means how many judges are there? 5 judges are there. Correct? 5 judges. Sometimes it is called as full bench. क्योंकि उतना ही जगह होता था बैठने को पहले हाई कोर्ट में एक बेंच पड़ा होता था एक साथ everyone used to sit together only so bench used to full whenever 5 members are sitting इसलिए इसको बोलते हैं full bench. Correct? So 5 members will be there, including CGI. CGI definitely should be there. correct? So CJI is also there. So it is a constitutional bench that will going to give a legal opinion to the president. And this thing is not available in USA. And this thing is not available at the level of state also. Like governor cannot take an advice from the High Court. So this is not available at the case of a state also. That means governor cannot take any advice from the High Court, and it is not available in USA also. Correct? We have covered 3 judges case in appointment of the judges. The third judge case था, it was a legal opinion. इसलिए उन केसेस को हम लोग ऐसा रेफरेंस लिखते हैं, RE, reference. Correct? The third judge case था, it was a legal opinion taken by the president from the Supreme Court. That is an example of article number 143. Court of record is done. Topic court of record. Nahi? Okay, now comes to court of record. This is mentioned under article number 129. Correct? Mentioned under article number 129, court of record. So it actually basically two meaning. What is the meaning of this court of record? Two meaning is there. First is whatever the judgment will come, whatever the judgment, the judgment they will going to actually include in this for perpetual memory. Perpetual memory in the sense later they will be used actually. That is a court of record. So court of record means judgments and acts of the Supreme Court. Judgments and acts of Supreme Court, they are recorded, and act of Supreme Court are recorded for perpetual memory. And testimony. Perpetual memory and testimony. What is the meaning of this term? Meaning ये है कि for example today Supreme Court has given any judgment. Tomorrow if any case is going on, then during that case, okay, previous ones whatever the case happened, they can be used as a evidence. Correct? In the last case you have decided this thing, so based on that only you have to decide this. So that means this court of record means whatever the judgment or acts of the Supreme Court, they will be used as a evidence in future cases. Correct? So whenever they are produced before any court, court will not going to deny them. So that is the value of this court of record. एक तो ये meaning होगा. Second meaning is they will be actually taught in universities. The law universities हैं, they will going to read these as a case study. These are the meaning of court of record. So court of record किसके पास है? Supreme Court and High Court only. Lower courts are not having, they are not a court of record. Only two courts are court of record, Supreme Court and High Court. इसीलिए देखो, for example, we used to have this cases name, either they are coming from the High Court or coming from the Supreme Court, but never from the subordinate courts. They are not having this court of record power. Clear this? Next is second meaning इसका क्या है? They can punish for the contempt of the court. Second meaning, they can punish for contempt of the court. First meaning already we have done. Second meaning है, courts basically they can punish for the contempt. It has power to punish for contempt of the court. This contempt of the court already we have covered. कब cover किया था? बहुत साल पहले, article number 19 में. Correct? 8 restrictions are there. वहां पे one restriction was contempt of the court. So there are two types of contempts were there: civil contempts and criminal contempt. Civil and criminal. Civil means whatever the judgment they have given, if you are not implementing that judgment, it is civil. Criminal basically means you are just lowering the authority of the court, you are interfering with them, correct? That is a criminal contempt. Civil contempt and criminal contempt. Correct? इसमें maximum punishment is 6 months or fine is up to 2000 rupees. So this together is known as court of record. Correct? The Supreme Court and High Court only both are having this contempt of the court also, and this records will be recorded. Correct? But subordinate courts are not having, not this also, not this also. Okay? Clear? So this is court of record done. Now next topic is judicial review. Judicial review. It basically review by judiciary. Judiciary. Simple. Review by judiciary. So what they are going to review? They are going to review law, acts made by legislature and executive or order. So judicial review is review done by judiciary. They are going to review law, acts or order that is made by or issued by legislature or executive. So जो भी law, for example, Article 370, what they were doing right now, judicial review only. So otherwise, why Supreme Court is discussing this? When 370 has been removed, then someone has filed a case, then Supreme Court is reviewing it. कि जो removal process था, it was legal or constitutional or not. That is judicial review. Same, for example, if any executive they take any decisions, like district magistrate had issued an order to arrest someone, then close relative of that person approach to the court, then court is going to check whether that order was legal or not. It was also a judicial review. So what is the background of that? From where they are getting this power? First important, the term judicial review is not available anywhere in our constitution. The term judicial review is not available anywhere in our constitution. So judicial review power basically flow from where? This power is flowing from three important article numbers: Article 13, 32 and Article 226. Article 13 याद है? Any law inconsistent with fundamental right shall be declared as null and void. So who is doing this? Supreme Court only, even High Court also. So from this Article 13 they are getting this power, judicial review. Article 32 क्या है basically? Constitutional remedies. They are also doing the same thing, and this is done through High Court. High Court is doing under Article number 226. But ध्यान रखना कि yes, power is flowing from Article number 13, but in Article number 13 anywhere they have not mentioned the term judicial review. Sometimes question आता है judicial review is mentioned under which article number? Article 13, 32, 226. आप इमोशनल हो जाते हो कि 13 में था ऐसा कुछ नहीं लिखा है. So Article number 13 में term judicial review is not mentioned. Correct? It is mentioned only in Lakshmikant. ठीक है? But not in the constitution. Correct? So this is clear abhi. Article 13, 12 and 226. That is judicial review. Next to the judicial activism. One more term you will get, judicial activism. So judicial activism basically है कि when judges they are actively involved in some of the cases, actively involved. They just want to know about the constitutional background of that particular case. Correct? That is judicial activism. That means they start working as an activist. They have this role of activist. Correct? So whenever they see any governance lacuna is there, lack of governance is there, or they think that this thing, whatever decision has taken by the government, or that is not constitutional properly, so they involve personally. That is known as judicial activism. That is activism by judiciary. Correct? When they are personally involved. So they do. कैसे इनका ये केस आएगा? एक सुमोटो खुद ही केस फाइल कर दिया. Correct? No one is approaching, still they are filing the case. PIL, public interest litigations. But this judicial activism has no constitutional backing. That means there is no article number that provides any power to judicial activism. So judicial activism has no constitutional backing, no constitutional support. Judicial activism has no constitutional support. Indian judiciary has invented it. Indian judiciary has invented it. When judicial review, it has constitutional support. Judicial activism has no constitutional support. Indian judiciary has invented it. Clear? They have invented it. So it is not available even in case of USA also. But judicial review, it is available in USA. Actually, we have borrowed from USA only. The term judicial review we have borrowed from the USA only. But USA के पास ये नहीं है judicial activism that we are having. Correct? Example, केशवानंद भारती case. If देखा जाए तो केशवानंद भारती case is completely unconstitutional. Completely because the thing is this, you cannot decide what is basic structure, what is not basic structure. It should be the right of the parliament only. Correct? You cannot do this. Like example, another important judicial activism role, you can say that this 3 judges case regarding appointment of the judges. You cannot change that procedure because whatever things in mentioned in the constitution, only parliament can change it. But you have changed entire procedure of appointing the judges. Even recently in Rajya Sabha, okay, one member of Rajya Sabha, I think Rajiv Shukla, he was saying that judiciary is talking about for everything reform. Even they want to reform BCCI also, that does not need any reform. Correct? But they never talk about their own reform. That is judicial reform. They want to enter everywhere. They want actually their own members in every appointment council, but they do not want any other member in their appointment council. Correct? So that is the cases. But this is how judicial activism works. Correct? The example is Keswananda Bharti case. Judicial activism example, Keswananda Bharti case. Correct? So it has no support. No article number is dedicated for judicial activism. Third आएगा judicial overreach. Judicial overreach or judicial adventurism. Judicial overreach or judicial adventurism. So there is very thin line between judicial activism and judicial overreach. Judicial overreach कब होगा? When there is a vacuum in any organ of the state. There are 3 organs of the states are there. One ये खुद है, 2 different है. Whenever there is any vacuum created in any of the organ of the state, this judiciary want to occupy that space. Correct? That is allocated to different organs. So they encroach into other areas. So there is a very thin line between judicial activism and judicial overreach. What looks judicial activism to me, it will look judicial overreach to you. Correct? So there is you can write there is a very thin line between judicial activism and judicial overreach. There is a very thin line between judicial activism and judicial overreach. As when activism crosses its limit, when activism crosses its limit and start becoming judicial adventurism, start becoming judicial adventurism, it takes the form of judicial overreach. It takes the form of judicial overreach. Clear? Example of judicial overreach क्या है? Like national anthem case. National anthem case, you must have heard about it. Judiciary said everyone need to stand up before starting of any movie, correct? So आप start खड़े हो गए और बैठे वहां पे सीट फोल्ड हो गया, आप गिर गए, ठीक है? So this is case that is no need to interfere by the judiciary actually. This is completely executive domain. Same for example, various environmental cases are there जहाँ पे judiciary involved too much. For example, their Delhi case was there. They have decided that those trucks who are more than 10 years of old, they cannot enter into Delhi city. But they forgot that all the milks, all the vegetables are coming from those trucks only. And when judges they have not received milk next day, then they came to know about it. So this is actually executive decision should be, but who is taking? Judiciary. Done. So that is judicial overreach. Now comes to difference between Indian Supreme Court and USA Supreme Court. Indian Supreme Court and USA Supreme Court difference. So USA Supreme Court is known as basically Federal Court of America. USA Supreme Court is known as Federal Court of America. This is Indian Supreme Court. This is Federal Court of USA. So difference first is Indian Supreme Court is having advisory jurisdiction. They are not having this. Next is original jurisdiction is narrow. यहाँ पे it is wider. Because this includes only federal case, only federal issues. In Indian Supreme Court is having original jurisdiction only in case of federal issues like center versus state, state versus state. और ये वाले में क्या होगा? This they include federal issues plus this maritime activities plus naval forces plus ambassadors related issues. So there actually original jurisdiction is larger. Now next is like this. Appellate jurisdiction is wider. Indian Supreme Court appellate jurisdiction is wider क्योंकि it includes civil case, criminal case, constitutional case also. And यहाँ पे appellate jurisdiction is narrow as it includes only constitutional case. Only constitutional case. But that includes constitutional also, civil also, criminal also. So it is wider, it is narrow. Done. Next is Indian Supreme Court jurisdiction can be enlarged by the parliament, can be increased by the parliament. Jurisdiction by parliament. This is limited by USA Constitution. Then that is the difference between Indian Supreme Court and USA Supreme Court. Next will be subordinate courts in India. Subordinate courts. At the district level, correct? District court and session court, correct? This is for the civil case. This is for criminal case. यहाँ पे जो पर्सन होगा उसको बोलते डिस्ट्रिक्ट जज. This is known as session judge. ठीक है. वहीं पर अगर मेट्रो सिटी हो, दिल्ली मेट्रो सिटी, it will be called as metropolitan court. Same, it will be called as metropolitan court then. ठीक है, समझ में आ रहा है. एंड जज को मेट्रोपॉलिटन जज भी बोलते हैं, बट दे आर डिसाइडिंग क्रिमिनल केस ओनली. सिविल केस यहाँ पे अगेन दे आर नॉट टू डिफरेंट पर्सन. If one particular judge is sitting and handling civil case, at that moment he will be known as district judge. अगर वो उधर पे बैठा है, then it is called as session judge. That is same judge है, but which case he is handling. If he is handling criminal case during the day, उस समय उसको session judge बोल देंगे. Otherwise we call that district judge. Clear is this? Now, appointment of district judge. So district judge, they are appointed by governor. state governor. After consultation with concerned high court. Concerned high court. So यहाँ पे council of minister is not involved. Correct? Council of minister is not involved. Simply क्या है, when you are actually complete your LLB, after that you need to take an exam. उसके बाद you will get some validity like 2 years, 3 years. It is based on different state का different है. Like 2-3 years का validity हो गया. After that क्या होता है कि you need to pass one more exam that is conducted by either state government or the high court. वो exam pass कर लिया and then you will be judicial officer. You will work for at least 7 years. उस 7 years के बाद then concerned high court will going to refer you for the district judge. Clear? So district judge or session judge, they are appointed by the governor after consultation with the high court. Clear? Next is, what is the qualification to become high court judge? So first important qualification, he should be an advocate or pleader. Qualification is advocate or pleader for 7 years. Advocate or pleader. जो अब मतलब PIL फाइल करता है, that is pleader. Second, recommended by High Court should not be already in service of central or state government. That means he should not be government employee. Simple. He should not be in the service of state government or central government. Resign आप कहाँ करोगे? Because you need to be advocate also. During that time you cannot do any other work. Clear? That is district. It is just like that only. For example, आप district magistrate directly तो नहीं बन जाओगे. You need to clear the UPSC exam. Then 6 to 7 years लगेंगे. Then you will become a district magistrate DM. उससे पहले आप SDM रहोगे. Different other posts are there. You need to continue with that. Same यहाँ पे भी है. So they also become district judge only after around 7 years. That is minimum requirement criteria है इनका. Now next is other judges. जो other than district judges, they are also appointed by the governor, but after consultation with the High Court and State Public Service Commission. समझ रहे? So other judges कैसे? Other judges appointment. Other judges are appointed by. Other judges are appointed by. Other means other than district judge. Other judges are appointed by governor after consultation with concerned High Court, concerned High Court and State Public Service Commission. यहाँ पे why State Public Service Commission involved? Because they conduct the exam. Judicial service exam used to be conducted at the state level. That is done by State Public Service Commission. So UPSC never conducted any exam that related to the judicial service. अदरवाइज वी आर हैविंग वन ऑल इंडिया सर्विस, जैसे अपने पास IAS IPS है, ऐसी ऑल इंडिया जुडिशल सर्विस इज ऑल्सो देयर. राज्यसभा ऑलरेडी पास्ड इट, बट स्टिल इट इज नॉट इम्प्लीमेंटेड येट. अगर ये इम्प्लीमेंट हो जाए देन वन मोर सर्विस विल बी एडेड एंड देन UPSC इज गोइंग टू कंडक्ट द एग्जाम फॉर दैट ओनली. बट स्टेट गवर्नमेंट दे आर नॉट रेडी फॉर इट, because then state government cannot control them. If suppose UPSC has done, then ultimately control will be in the hand of central government, so they are not connected. Clear? That is other judges. Next is Lok Adalat. Next topic, Lok Adalat. Lok Adalat. So it is basically alternative dispute redressal mechanism. It is basically an alternative dispute redressal mechanism. Alternative dispute redressal mechanism. Why we are saying alternative? Because it is not the same like Supreme Court, High Court and subordinate court. It is completely different from it. Correct? It is just substitute of all these things. Because those who are approaching subordinate courts, High Court, Supreme Court, क्या हो रहा है कि they are taking too much time to decide a case even. So for that purpose, we came with this alternative dispute redressal mechanism. Correct? So under this, actually, we can take both type of cases. Civil case as well as criminal, both cases can be taken under Lok Adalat. ध्यान रखना, civil case as well as criminal case, both can be taken under Lok Adalat. Lok Adalat, they are statutory body or constitutional body? Statutory body, correct? So statutory body, that means there must be one act. So act is Legal Service Authorities Act 1987. पढ़ा होगा 1 DPSP. किस आर्टिकल नंबर में पढ़ा था ये लीगल सर्विस अथॉरिटी एक्ट? Which was the article number where we have covered Legal Service Authorities Act? NALSA, SALSA. But under which article number? याद है? पॉलिटी में ही सोचना है, इकोनॉमी में नहीं है ये. ठीक है. फ्री लीगल एड अंडर विच आर्टिकल नंबर? फ्री लीगल एड 49 में ये. क्लोज हो, it is 39A. Correct? 39 capital A. Now composition of Lok Adalat. So composition में होगा one chairman, 2 members, and third is one social worker. These are the members of the Lok Adalat. Chairman, 2 members and 1 social worker. तो ये chairman है, he should be sitting or retired judge. और जुडिशल ऑफिसर, डेफिनेटली हाई कोर्ट इसको नहीं होगा वो, ही विल बी डिस्ट्रिक्ट जज. और अब जुडिशल ऑफिसर लिख लो इसको, इससे बेटर रिटायर जुडिशल ऑफिसर, सिटिंग और रिटायर्ड जुडिशल ऑफिसर. अदर 2 members, they are basically lawyer and one is social worker, that is NGO वाला guy, because he is going to participate there as a middleman for both parties. Correct? And Lok Adalat follow only one principle, that is principle of natural justice. That's it. No civil procedure code, no criminal procedure code, कुछ भी follow नहीं करना है. only follow the principle of natural justice. They follow only this principle of natural justice. Correct? They do not follow civil procedure code, criminal procedure code, evidence act, कुछ भी नहीं. Only principle of natural. Principle of natural क्या है? No one will be judged in his own case. जैसे मेरा ही केस और मैं ही जज हूं वहां पे. That is not allowed. And everyone should be given proper opportunity to be heard. That is principle of natural justice. And both civil and criminal cases can be taken here under Lok Adalat. But criminal cases जहाँ पे compromise is not possible, they will not be taken. See, होता compoundable, non-compoundable. So compoundable हर compromise is possible. So wherever this compoundable जो है punishment or offense, only in that can be taken here. But जो भी ऐसे हैं जहाँ पे compromise is not possible, like example, they are very heinous crimes. Those criminal cases will not be taken here. Because यहाँ पे main मुद्दा क्या है? Compromise करवाना किसी तरह दोनों पार्टी का. And whatever the final award will come, final judgment, it cannot be challenged anywhere. Correct? So final award you can write. Decision of Lok Adalat is ultimate and binding on all parties. Decision of Lok Adalat is ultimate and binding on all parties. No appeal is available. No appeal is available. Correct? You cannot do any appeal against the judgment given by Lok Adalat. Reason ये है कि because आपने ही बोला है ना कि yes, I am okay with this judgment. So now again, if someone is going to file an appeal in High Court, then what is the purpose of Lok Adalat? Correct? So no appeal is possible. And no court fees are there. No court fees here. There is no court fee. Suppose example, your case is already going on in any subordinate court, any district court, your case is going on, and you already paid the fees, but your case now transferred to the Lok Adalat. Correct? No, now Lok Adalat is deciding that case. So whatever the fees you have paid there, it will be reimbursed back to you. Clear? So that is Lok Adalat done. From any court or any court, correct? But only thing is, all the civil, all criminal cannot be transferred. Criminal, I told you, only those crimes which are less heinous, have a compromise is possible. Same in civil case, particular amount. Of like example, up to 20,000 rupees. After that, definitely you have to go there court only. Clear? So this is the end of the judiciary chapter. So next chapter will be local self-government. So emergency chapter already done. Central state relations done. And this is the last chapter. Except constitutional bodies and non-constitutional bodies. Only two more chapters have remained. Constitutional, polity done from my side. ठीक है, अपना देख लो. ठीक है, मेरे साइड से खत्म हो जाएगा. Only constitutional, and they require not more than 3 to 4 classes. Constitutional and non-constitutional bodies. वहीं से we can start then governance also. Done. So I think before this new year I will complete everything. आप नए साल में पॉलिटी के साथ जाए. ठीक है. Governance क्या है? We constitutional bodies we are going to cover. So half of the portion will be covered there only, like CBI, NIA, everything. Some of the, like example, when UPSC we will going to cover, at that time we will cover this civil service reform, role of the civil service and democracy. These chapters will be covered there only. Election reform, that will be covered during election commission, constitutional bodies. वहाँ पे it will be covered. ठीक है, done. So now comes to local self government. So local self-government, basically, it is a third tier of government. After two, federalism we are having. So one already tier is we are having, that is central government, then state government, and then we'll come to the local government. Basically, two types of governments we are having. One we call normally panchayats. Another we called municipalities. So panchayats are in basically rural areas. Municipalities for urban areas. Right? Panchayats, they are in rural areas and then urban areas. पंचायत में भी हम लोग कवर करेंगे. There are again 3 different types are there, like gram panchayat, and second we will be having panchayat samiti, and third is jila parishad. Municipalities, again we will have 3 types of bodies: nagar palika, and another is municipal council, and third is municipal corporation. Correct? Municipal corporation. For example, अगर आप जैसे मध्य प्रदेश का नाम लेंगे, मध्य प्रदेश total 16 municipal corporation is there in Madhya Pradesh. Municipal council, 99 municipal councils are there, and municipal this nagar palika, around 300 nagar palikas are there. अगर आप कर्नाटका की बात करें तो कर्नाटका में there is around 11 municipal corporations are there. Correct? So municipal corporations are for big cities only. And numbers are not important at all. Numbers are not important. Just I am giving you based on how many numbers they are there. आप एक सोच सको उनके बारे में, ठीक है? तो म्युनिसिपल कॉर्पोरेशन फॉर बिग सिटीज, जब पॉपुलेशन इज मोर देन 10 लाख, करेक्ट? एंड देन मिडिल में म्युनिसिपल काउंसिल, छोटा छोटा है, टायर 2 सिटीज के लिए, एंड टायर 3 सिटीज के लिए नगर पालिका. इतना क्लियर हुआ? एंड सेम यहाँ पे ग्राम पंचायत, if a village that is big in the sense at least 1600 to 2000 voters should be there, voters, then it will be a one nagar panchayat. If villages are small, like jahan pe voters sirf 600 hai, then 2-3 different villages, they will come together, they will going to make one gram panchayat. Different gram panchayats, like 9 to 10 gram panchayats come together, they are going to make one panchayat samiti. Then different panchayats means they will come together, they are going to make jila parishad for entire jila. Correct? इतना क्लियर हुआ? तो जिला पर लाइक जिला पंचायत अध्यक्ष होता है ना, ये स्कॉर्पियो में घूमता है, ठीक है? ठीक है, दैट इज जिला परिषद. ठीक है, यहां से फॉर्च्यूनर आ जाएगा तो विधायक हो जाओगे. ठीक है, सो दिस इज डन. दिस इज द थिंग. दिस इज रूरल एरिया, दैट इज urban area. Now the background of this local self government. So local self government से क्या फायदा क्या हुआ? एक होता है डिसेंट्रलाइजेशन, एक होता है डेलीगेशन. दोनों में डिफरेंस क्या है? डिसेंट्रलाइजेशन में रियल पावर यू आर ट्रांसफरिंग टू देम, रियल पावर. करेक्ट? अल्टीमेटली रियल पावर मींस नाउ यू आर नॉट able to take away that power. That is decentralization. Delegation means that power has been given but it can be taken any moment. That is delegation. That is the difference between delegation and decentralization. I told you the example of Britain. Britain they are having delegation. British Parliament, they have delegated power to the Scottish Parliament, to the Welsh Parliament, to the North Ireland Parliament, but they can take away any moment. But India with the Indian Parliament, whether they can take away the power of the state, no, it is not possible. Correct? So that is the decentralization. So इससे क्या होगा? Decentralization होगा. And since we are doing at the rural level, at the not in the rural, at the ground level, इसलिए इसको बोलते हैं grassroots democracy. We call that grassroots democracy. These terms you have to use in your mains answer. जहां पे मौका मिले इनको भर देना है. Grassroots democracy, correct? Decentralized democracy, participatory democracy, ग्राम स्वराज, करेक्ट, ट्रांसपेरेंसी, बॉटम टू टॉप अप अप्रोच, ये सारे वर्ड आपको ध्यान में आने चाहिए व्हेनेवर यू आर राइटिंग एनी आंसर रिगार्डिंग दिस पंचायत समिति, सॉरी दिस लोकल सेल्फ गवर्नमेंट. Decentralizations, democratic decentralizations, people's participation, grassroots democracy, transparency, accountability, Swaraj, Gandhi's dream. आपको बस भरना है वहां पे. देखो 10 to 20 वर्ड तो यहीं पे हो गए. ठीक है, 10 वर्ड्स क्वेश्चन से चुरा लेना, खत्म हो गया. नेक्स्ट इज इवेल्युएशन ऑफ पंचायती राज. So when this local self government came to India, कब आया था इंडिया में? मतलब हम पैदा नहीं हुए थे तब, हमारे सामने नहीं था. So, कब आया ये? 1992, 73rd 74th अमेंडमेंट, उससे पहले का है ये. एंशियंट इंडिया पढ़े थे, उसमें भी था ये लोकल सेल्फ गवर्नमेंट, करेक्ट. इवन ब्रिटिश टाइम में भी दिस लोकल सेल्फ गवर्नमेंट वाज देयर. व्हाट हैपेंड इन 1992 बेसिकली constitutional status was given, correct, constitutional status was given. Even in India it started in 1957 only, after independence. Before time, British time also this was there. So there is few committees are there. So important committees कौन सी है? बलवंत राय मेहता कमेटी, बलवंत राय मेहता कमेटी, बलवंत राय मेहता कमेटी. Balwant Rai Mehta Committee. So this committee has recommended about local self-government. This committee was in 1957, Balwant Rai Mehta Committee. There were two programs already running for the grassroots democracy, and these two programs were, first is Community Development Program, and second program was National Extension Service. So this Balwant Rai Mehta Committee was set up to study these two programs, Community Development Program and National Extension Service. Correct? They were discussing about these two programs कि why these programs are failed. जबकि यहाँ पे भी वही है, community participation, correct? National Extension Service means whatever the services national government is having, they are extended to the people directly. So during this study, Balwant Rai Mehta has recommended democratic, decentralized local government. He has recommended for it democratic, decentralized local government, because he told that ki bureaucrats, they are not allowing people to involve in any community development programs. वही ब्यूरोक्रेट्स थे, उन्होंने एग्जाम पास किया था, यूपीएससी क्लियर किया था, उनको लगता था उन्हीं को सब आता है. So because of that this happened. So democratic, and he himself was the chief minister, second chief minister of Gujarat, Balwant Rai Mehta Committee. So this committee has given some recommendations. Again, I will give you some recommendations. जरूरी नहीं कि these things today also valid. They are just recommendations during that time. Today's situation is different. So what is the recommendations were there? So very first recommendation was 3-tier panchayati raj system. First recommendation is 3-tier panchayati raj system. 3-tier in the sense, like example, first is Gram Panchayat, Panchayat Samiti and Jila Parishad. Gram Panchayat, Panchayat Samiti and Jila Parishad. Second is, at this level, election should be direct. That means people directly involved here. They are voting and electing Gram Panchayat Sadas, members. At this two level, indirect elections. Again, this is not the present condition. This is what he has recommended. So at Gram Panchayat, elections should be direct. That means people directly, we actually as a voter, electing Gram Panchayat members. Then this Gram Panchayat, elected Gram Panchayat members, they will going to elect the Panchayat Samiti members. And Panchayat Samiti members will going to elect the Jila Parishad. Done. Next is, planning and development are the primary objective of Panchayati Raj system. Planning and development is a primary objective of Panchayati Raj system. Planning and development is a primary objective of Panchayati Raj system. Fourth is, Panchayat Samiti should be the executive body. And Jila Parishad supervisory body. Panchayat Samiti is the executive body. That means whatever the schemes are there, they will be implemented by the Panchayat Samiti. And whether this implementation is proper or not, who is going to check it? Jila Parishad. This was his recommendations. And district collector should be the chairman of Jila Parishad. Next is district collector DC as the chairman. Jila Parishad. Abhi right now he is not the chairman of Jila Parishad. Abhi already we are having one Jila Panchayat Adhyaksh. Right? पहले क्या होता था कि whatever the post is remain empty और नया post बना दिया, they used to get everything to the district collector. That is the reason he became most powerful person during that time. Next is provision of resources. Resources, they have not talked about directly about taxes, but ये बोला कि some money need to be transferred to them. Provision resources to help them to discharge their duties. Correct? Without money तो कोई फायदा नहीं है. Money आपको देना है. अब for the money, if already the state government, no matter whatever power you give, without money there is no use. घर में भी होता है ना, मनी जिसके हाथ में पावर उसी के हाथ में है. पॉलिटिकल पार्टी में भी सेम है. तो सेम यहाँ पे था कि एटलीस्ट मनी शुड बी गिवन फर्स्ट टू देम आल्सो सो दैट दे कैन डिस्चार्ज देयर ड्यूटीज प्रॉपर्ली. If they are too much dependent for the money on the state government, then what is the purpose to have this third tier of government? So based on these recommendations, Rajasthan became the first state to implement these recommendations. So Rajasthan has implemented all these recommendations in 1959, followed by Andhra Pradesh. Then Rajasthan became the first state, and second was Andhra Pradesh. So ये बराबर अच्छे से चला. This thing ran smoothly, properly. After that, what happened? 19 1959. Okay, 1959, that is the year. अभी क्या हुआ कि then Indira Gandhi came. Indira Gandhi became more powerful. Emergency came. So Indira Gandhi stopped conducting the election even because it was not having constitutional status. So there is no need of to have election also. And most of the state who was there actually? Congress only. Correct. So whatever things Indira Gandhi used to say, Congress CM, they used to follow the same thing. So because of that, what happened? In 1977, basically, we are having one more government, that is Janata Party government. Janata Party government को लगा कि we should have one more committee. और UPSC का सिलेबस भी बढ़ाना है. ठीक है, बहुत टाइम से क्वेश्चन इसी पे पूछ रहे थे. So फिर जनता पार्टी गवर्नमेंट came with new, that is Ashok Mehta Committee, 1977. Ashok Mehta Committee, 1977. Now Ashok Mehta Committee, they need to give recommendations. They cannot give the same recommendations as Balwant Rai Mehta Committee. So UPSC need to ask questions, what is the difference between these two committees? So जो उन्होंने बोला उसका अपोजिट हमको बताना है. ठीक है. So अशोक मेहता ने बोला no 3 tier, it should be 2 tier. Correct. So first is came 2 tier actually only. District level and mandal level. That's it. District level पर जिला परिषद. This is mandal panchayats. So around 20,000 total population जहाँ पे complete होगी. The villages, total village population or number of group of village population is 20,000. That will be one mandal panchayat. So no gram panchayat. ठीक है. Then बलवंत राय मेहता ने किसको एग्जीक्यूटिव बॉडी बोला था? पंचायत समिति को. ये तो बोल नहीं सकते. इन्होंने बोला जिला परिषद should be the executive body. Second is जिला परिषद should be the executive body. करेक्ट. ये तो पैसा बर्बाद अगर सेम बता दिया. Next thing, third is compulsory taxation power. Compulsory taxation power. That means they should have this power to collect the taxes also. उन्होंने बोला सिर्फ provision of resources, they have compulsory taxation power. So they can collect the taxes also. फिर उसके बाद थर्ड फोर्थ, ए मिनिस्टर फॉर पंचायती राज. ए मिनिस्टर फॉर पंचायती राज. एक पर्टिकुलर डेडिकेटेड मिनिस्टर शुड बी देयर इन द स्टेट काउंसिल that is only for panchayati raj system. Right now we are having at the most of the state we are panchayati raj ministers. Even central level पे we are having one minister for the take care of panchayati raj. And last में बोला constitutional recognition. Constitutional recognition to be given. Constitutional recognition to be given. Constitutional recognition to be given. That means एक article number भी दे दो ताकि we can ask some specific questions from the student under which article number this comes. ठीक है. So ये उन्होंने इतना बोल दिया. उसके बाद क्या हुआ कि जनता पार्टी गवर्नमेंट खुद ही चली गई. इनका रिपोर्ट भी चला गया. किसी ने इम्प्लीमेंट ही नहीं कर पाया. करेक्ट. उसके बाद क्या हुआ, प्लानिंग कमीशन एक था बॉडी जो अपने आप को ज्यादा समझता था उस समय. तो प्लानिंग कमीशन ने हमें भी एक कमेटी देनी चाहिए ना. तो प्लानिंग कमीशन सेट अप वन मोर कमेटी दैट कॉल्ड जीवीके राव कमेटी. जीवीके राव कमेटी in 1985. Third committee is GVK Rao committee. 1985. It was set up by Planning Commission. So they have recommended very few things basically. One is post of DDC as CEO of Jila Parishad. DDC, District Development Commissioner. Post of DDC is the CEO of the Jila Parishad. अभी जो यूपीएससी में क्लियर करते हैं आईएएस बनते हैं आफ्टर 3 to 4 years of service they become CEO of the Jila Parishad right now. So they work as a DDC. And second problem is elections. So they call about regular elections also. इतना ही इनका है, that's it. So they given only 2 recommendations. पैसे टाइम पे नहीं पहुंचे तो ज्यादा रिकमेंडेशन नहीं दिया. ठीक है. So next is LM Singhvi committee. Rajiv Gandhi has appointed this committee. LM Singhvi committee. The term Lokpal was coined by this man only. LM Singhvi. So this committee was set up basically in 1986. So first most important इनका यही था, constitutional status should be given. First था constitutional status should be given to the Panchayati Raj system. Constitutional status should be given to the Panchayati Raj system. This was the very first requirement. Okay, everyone was thinking कि no matter whatever the recommendation you give, if there is no constitutional status, then election will not be held properly. Then what is the use of other recommendations? So इन्हीं के मतलब when he has said this constitutional status should be given, then Rajiv Gandhi brought some amendments to the 64th and 65th amendment. But problem is happened that these amendments are not able to be passed properly. And then comes to 73rd amendment 1992, then constitutional status was given. So Narasimha Rao government actually brought 73rd amendment 1992. So come back to 73rd amendment 1992. Heading is 73rd amendment 1992. So the Prime Minister was Narasimha Rao. So this amendment has made some changes in the constitution. What are those changes were there? First change was this. One part was there, part 9. This part 9 was added to the constitution. Total how many parts are there? 12 parts are. 22 parts है और ये कौन सा ऐड हुआ पार्ट 9. तो ये तो पहले से ही था, करेक्ट. और जब आप बोल रहे हो ऐड किया 1992 में, तो क्या था कि बिफोर 1992 बेसिकली टिल 1956 जब रीऑर्गेनाइजेशन ऑफ द स्टेट हैपेंड ना, रीऑर्गेनाइजेशन ऑफ द स्टेट टिल 1956 अंडर पार्ट 9 देयर वर सम स्टेट्स जो आते थे पार्ट डी में. पहले स्टेट्स 4 पार्ट्स में डिवाइड थे, पार्ट ए, पार्ट बी, पार्ट सी, पार्ट डी. जो पार्ट डी की जो टेरिटोरीज थी दे वर इंक्लूडेड अंडर पार्ट 9 अर्लियर. ध्यान रखना. अभी राइट नाउ स्टेट्स आर डिवाइडेड इनटू 2 पार्ट्स बेसिकली. आप सोचो स्टेट्स और यूटीज, और थर्ड होता है एक्वायर्ड टेरिटोरी, दैट्स इट. अर्लियर स्टेट्स वर डिवाइडेड इनटू 4 पार्ट्स, पार्ट ए, पार्ट बी, पार्ट सी, पार्ट डी. जो टेरिटोरीज दैट कम्स अंडर पार्ट डी they were included under part 9. But since this division part A, part C, D, this was removed in 1956, so part 9 space was empty. फ्रॉम 1956 टिल 1992। यहाँ पे जगह खाली थी, प्लॉट इनको खाली दिखा, अपना इसमें लगा दिया। करेक्ट, समझ में आ गया अभी? सो पार्ट 9 वाज एडेड हियर बाय 73rd अमेंडमेंट 1992. One schedule was added. What was the schedule name? Number 11th schedule was added. Correct, 11th schedule was added. Clear hai? Under 11th some subjects are there. How many subjects were there? 29 subjects were there. Normal subjects थे, जैसे cleaning of the roads, primaries, okay, this medical facility, minor projects, irrigation वाले, irrigation मतलब मेज, irrigation का 3 टाइप्स के प्रोजेक्ट्स होते हैं, एक मेजर, एक मीडियम, एक माइनर। क्या डिफरेंस है इन तीनों में? स्पेलिंग डिफरेंस है, ऐसा नहीं है, कुछ तो डिफरेंस रहा होगा ना। मेजर इरिगेशन प्रोजेक्ट्स, मीडियम एंड देन स्मॉल, और माइनर जिसको बोलते हैं। मेजर होता है कि व्हेन एनी प्रोजेक्ट दैट कैन कवर मोर देन 10,000 हेक्टेयर्स ऑफ द लैंड, दैट इज कॉल्ड एज मेजर इरिगेशन। And medium irrigation projects are those which covers from 2,000 hectares till 10,000. And those less than 2,000 hectares, they are considered as minor irrigation projects. So they will be covered under local self-government. Clear this? Some article numbers were added. So article they have added 243 से लेके article number 243O. 243 to आर्टिकल नंबर 243O. ओ के बाद आएगा कौन सा आएगा अभी? 243 ओ के बाद ABCD पढ़ो। P that will start with municipalities. So municipalities का आर्टिकल स्टार्ट फ्रॉम आर्टिकल नंबर 243P. So this is only for the पंचायत और रूरल एरियाज के लिए। Correct? And this 73rd amendment basically acts have 2 parts. One we call that compulsory provisions, compulsory, another is voluntary. Compulsory means it is same for every state, no matter which state is, that provisions will be valid for every state. Voluntary means state government के पास ये role है, they can change that also. So 2 types of provisions are there under 73rd amendment. Compulsory provisions, that is same for every state. Voluntary provisions that can be changed by particular state. Clear अभी? अब ये ग्राम पंचायत जो बनेगा आपके गांव में, जैसे फॉर एग्जांपल we are having 3 organs of the state. 3 organs में we are having, one is legislative body, another is executive, other is judiciary. We are just leaving judiciary right now. So under this we are having parliament, and यहाँ पे we are having council of minister. स्टेट में भी वही है, स्टेट लेजिस्लेचर एंड काउंसिल ऑफ मिनिस्टर। सेम वे पंचायत में भी है अपने पास, जो अंडर लेजिस्लेटिव ऑर्डर दैट इज कम्स ग्राम सभा, and under executive will come gram panchayat. This is the most favorite topic in interview, most favorite. उनको पता है कि 80% जनता को पता ही नहीं डिफरेंस क्या है। They ask what is gram sabha, और आंसर होता है ग्राम सभा is elected body, elected by we the people of India. No. So what is gram sabha basically? दोनों डिफरेंस क्या है, ग्राम सभा एंड ग्राम पंचायत? कभी गांव गए हो? अब तो भारत हो गया, अब तो जाना चाहिए ना, ठीक है। सो ग्राम सभा क्या है? ऑल मेंबर्स हु कैन वोट, एक्चुअली जो 18 प्लस जो भी मेंबर्स हैं इन दैट विलेज, और जिनके नेम इन द वोटर लिस्ट में भी है, टुगेदर दे आर नोन एज ग्राम सभा। उसके बाद यही लोग दे इलेक्ट सम मेंबर्स, करेक्ट, एंड दे आर कॉल्ड एज ग्राम पंचायत। सो ग्राम पंचायत इलेक्टेड बॉडी है, but this is not an elected body. This is basically all the members in that village who are having 18 plus age and having the vote in that village. These people will call as Gram Sabha. So Gram Sabha basically everyone is included here, correct? Gram Sabha mein everyone is included. So that is it is more participatory in nature. देखो पार्लियामेंट में everyone is not included, but यहाँ पे everyone is included. So इसलिए उसको तो participatory democracy. ग्राम पंचायत में क्या है? कुछ होते हैं पंच, उसके ऊपर एक होता है सरपंच. पंच बेसिकली क्या है कि जो भी आपका विलेज है, बड़ा विलेज है, then that village will going to be divided into different ward. डिफरेंट वार्ड बनाएंगे, जैसे कॉन्स्टिट्यूएंसी बनती है ना, ऐसे डिफरेंट वार्ड्स बनेंगे. एक एक वार्ड्स को वन पंच विल गोइंग टू एक्चुअली रिप्रेजेंट. उसके बाद एंटायर विलेज के लिए वी विल बी हैविंग वन प्रधान, जैसे प्रधानमंत्री. सो दिस पंच दे आर नथिंग बट मिनिस्टर्स एंड सरपंच इज प्राइम मिनिस्टर, करेक्ट और नॉट? So this punch number will be around 5 to 20 based on the population, and this one will be सरपंच, जिसको प्रधान सेवक भी बोलते हैं. We call it प्रधान सेवक और simply प्रधान, correct? इतना समझ में आया? So पंच, they are the members representing different wards of that village, and this is सरपंच, that is प्रधान, head of that पंच. करेक्ट? ऐसे ही फॉर एग्जाम्पल इसको आप इक्वल कर सकते हो काउंसिल ऑफ मिनिस्टर, इसको इक्वल कर सकते हो प्राइम मिनिस्टर. क्लियर दिस? अब प्राइम मिनिस्टर को सपोर्ट करने के लिए वी आर हैविंग वन सेक्रेटरी आल्सो. वी कैन कॉल कैबिनेट सेक्रेटरी, वी कैन कॉल प्रिंसिपल सेक्रेटरी आल्सो. इनके पास भी सेक्रेटरी होना चाहिए सरपंच के पास. तो सरपंच इज आल्सो हैविंग सेक्रेटरी, उसको बोलते हैं पंचायत सेक्रेटरी. पंचायत सेक्रेटरी. So this sarpanch is having one secretary also, that is a government officer, government civil servant, correct? And that is called as panchayat secretary. You have seen panchayat web series? Jitu bhaiya, he was a panchayat secretary, correct? Clear abhi? अभी समझ में आ गया? अभी नहीं समझ में आया था, गांव में जाना है, ठीक है? सो यू अंडरस्टूड दिस? इलेक्शन लड़ना है, ठीक है? फंडिंग बहुत कम है, 6 लाख रुपीज में यू कैन विन द इलेक्शन आल्सो. इन 1 year you will get 50 lakh to 1 crore rupees मैक्सिमम प्रॉफिट. बनाना क्या है वहां पे? रोड ऑलरेडी वहां पे है ही, बनाना क्यों है? ठीक है, बल्ब सुबह लगाना, रात को निकाल लेना है, अगली अगली दिवाली फिर वही लगाना है, ठीक है? सो पैसा बहुत है यहाँ. क्लियर हो गया इतना? ओके, सो द डिफरेंस ग्राम सभा एंड ग्राम पंचायत क्लियर? अभी डिफरेंस बिटवीन ग्राम पंचायत एंड ग्राम सभा. पंच इज क्लियर एंड पंच सरपंच इज क्लियर. सी पंच जो है, पंच इनको मेंबर्स बोलते हैं. मेंबर्स दे आर इलेक्टेड ऑलवेज डायरेक्टली. डायरेक्टली मींस पीपल डायरेक्टली इलेक्ट देम. दिस सरपंच that can be direct also, that can be indirect also, depends on the state. Some of the states में they are direct, so directly we are electing. Some is indirect. Indirect means all of these punch में one punch will be the सरपंच. इतना क्लियर हुआ? So ग्राम सभा done. So basically we are having right now 3 tier system. Right now अपने पास यही सिस्टम है जो बलवंत राय मेहता बोल के गई थी, नॉट अशोक मेहता, बलवंत राय मेहता. This is ग्राम पंचायत, this is पंचायत समिति, and this is जिला परिषद. यहाँ पे आपके पास पंच होंगे और मेंबर्स. दिस इज सरपंच, प्रधान. इनके पास भी यहाँ पे मेंबर्स होंगे एंड समिति अध्यक्ष. Here also members एंड जिला पंचायत अध्यक्ष और प्रेसिडेंट, अध्यक्ष या प्रेसिडेंट सेम है, और चेयरमैन। Clear this? Now, always directly elected, always. They are also directly elected. And they are also directly elected only. Always. So members at all levels, they are directly elected. Sarpanch, डायरेक्टली और इनडायरेक्टली दोनों पॉसिबल है यहाँ पे, बेस्ड ऑन स्टेट। अध्यक्ष ऑलवेज इनडायरेक्टली इलेक्टेड, एंड जिला पंचायत अध्यक्ष ऑलवेज इनडायरेक्टली। Right? So this is a compulsory feature. Every state में जो members हैं, they are always directly elected. This is compulsory. This provision, sarpanch, directly or indirectly, it is a voluntary provisions. It can be decided by the state. Like Jila Panchayat में जो members हैं, they are directly elected. Like example, in one Jila Panchayat, we have elected around 20 members. अब this 20 members है, इसमें से one member will be the Jila Panchayat अध्यक्ष. इसमें कौन होगा? That member who will going to give a promise, he will give every member 1 Fortuner and 1 crore rupees. He will become जिला पंचायत अध्यक्ष. सिंपल लॉजिक है, वहां पे ये मार कुटाई नहीं है, सिंपल लॉजिक मनी का. Then okay, so this is the elections at the different level. Then now comes to reservation. Reservation is also there. Reservation for SC and ST according to the population, and 1/3 seats are reserved for the women. 1/3 seats are reserved for the women, and for SC and ST according to the population. One-third seats for the women, and SC ST according to the population. So this is the compulsory provisions every state should follow. Some of the states they can increase the reservation for the women also. So some states they have increased till 50% also. But at least 1/3 it is compulsory. One more voluntary provision is there. State legislature can give reservation to the backward class. This is voluntary. So state legislature will decide on the reservation of backward class. That is a voluntary provisions. Now duration of panchayat कितना है? 5 years. So panchayat duration is 5 years. After 5 years, election should be conducted. Five years. अभी फॉर एग्जाम्पल इसमें क्या है कि लाइक एग्जाम्पल दिस इज इंटायर 5 years दिस लाइक दिस स्टार्ट 2020 एंड दिस इज 2025 तक चलेगा. अगर कोई ऐसा है दैट इज गोइंग टू एंड इन द मंथ ऑफ लाइक एग्जाम्पल दिस only 6 months remain or panchayat is dissolved, only 6 months remaining and panchayat is dissolved, then no election is required. यहाँ पे no election is required. If only 6 months or less than 6 months remaining, then no election is required. If more than 6 months is remaining, then election is required. Like example, if any panchayat, it is resolved here only. Here in the sense like 3 years. Dissolve हो गया. Still there are 2 years are there. Then election needed. और जो न्यूली इलेक्टेड पंचायत होगा ना, that newly elected panchayat will function only for remaining 2 years, not for 5 years. So that one nation, one election is possible. समझ में आ रहा है? So if in panchayat, any panchayat that dissolved before completion of its term, then new election is required and new elected panchayat will function only for the remaining duration. Correct? Because when this 5th year will come, then every panchayat should go elections in the same time. Done? Same concept we can apply for one state, one elections or one nation, one election also. Especially in state governments, में ये problem है, they can be dissolved earlier. If they are dissolved earlier, whatever the elected government is coming, that elected government should run only for the remaining time. एक तो ये better plan है. Or we can have two different, for example, midterm, एक midterm elections और एक सबके साथ elections. Midterm में क्या है कि whatever this state they are going for the elections, midterm में करवा लो या wait for the general elections. Only 2 times election will be there. Clear this? Even till 1967, elections was one nation, one election only. It was Indira Gandhi who has disrupted this cycle. Correct? उसके बाद सभी ने ट्राई किया डिसरप्ट करने का after applying this article number 356. Next is disqualification. So disqualification, same as state legislative assembly members. Disqualification will be same as state legislative members. जो MLA और MP के लिए MLA के लिए होता है same, whatever the disqualification mentioned for the MLA, same will work for them only. Except one. कौन सा है ऐसा disqualification? It is not same. दिमाग लगाओ अगर है तो. It is same except one. Yes? बताओ. Age. उनके लिए एज कितना है मिनिमम? 25, 24 का तो एमएलए नहीं हो सकता. It will, that person will be disqualified. But यहाँ पे 21 years is the age. So लिख लो except age. Except age. वो minimum age requirement here is 21 year. Clear? Minimum age is 21 year. State legislature can provide any other disqualification also. State legislature can add any other disqualification also. Example like metric pass. It is there. Like in Haryana, it is there. Metric pass would be their person, then that person can contest the elections. Even MLA or MP, there is no such thing is there. MLA, even though you are not a metric pass, still you can contest elections. But Haryana mein, you should have a metric pass, then only you can. Yes, because you have to deal with the USA. What is the necessary of this metric pass at the local level? They are not making foreign policies. उनसे टॉयलेट नहीं बन रहा है. हाँ मैट्रिक पास की बात कर दी है, करेक्ट है ना. बट वहां पे है. राजस्थान में भी था, बट अगेन अशोक गहलोत गवर्नमेंट के दे रिमूव दिस क्राइटेरिया. इवन सम ऑफ द स्टेट लाइक एग्जाम राजस्थान ही था, उन्होंने ये बोला जिसके घर में टॉयलेट नहीं है, दे आर नॉट एलिजिबल for the election even. Next is State Election Commission. State Election Commission. Yes. क्या चाहिए? ब्रेक चाहिए? ब्रेक मांगो, डेमोक्रेसी है. ठीक है. State Election Commission. So this election commission is different. This is not the same as central election commission. This is different state election commission. So this state election commission basically conduct the election for the panchayat and municipalities. Correct. This state election commission conduct the election for panchayat and municipalities. This is different from the central election commission. This is different from the Central Election Commission. So this State Election Commission is also a constitutional body. Then take a break. ठीक है. Power and functions. Next feature is power and functions. So power and functions. So who will decide it? State legislature. State legislature may give such power and authorities. State legislature may provide such powers and authorities as may be necessary. Correct. So this is also a voluntary function. It is not a compulsory function. That means state legislature will be different for different states. So this term that is may mentioned. So may means they can, and here may means they will not. So this is the problem of panchayats we are having. यहाँ पे लिखा है कि they can provide such power and authority, but they are not providing many power and authority. Basically 3F से problem है. 3F problem is facing by local governments. First F is function. Proper function is not delegated to the panchayat and municipalities. There's a lot of overlapping happened. Second F problem is basically fund. Money is not given to them. Taxation authority is not given to them to collect the taxes. And third F is functionaries. This is called as 3F problem of local government. Function not properly allocated. Fund no power has given to collect the taxes. And functionary, they are not having their own officers. They are dependent on the state government. Like you are having for central government IAS, state के लिए we are having PCS, but we are not having VCS, Village Civil Service. Correct? एक और preparation हो जाते, ठीक है? But this is not there. So they are dependent basically on civil servant that is appointed by the state government. So state government only they are going to remove them. So there is no accountability of the functionaries to the local government. Like panchayat secretary. So Pradhan cannot remove panchayat secretary. Only state government can remove. So because of that, this issue is happening. Clear? Power and function. Same problem is with finance. Next problem is finance. यहाँ पे भी सेम है. स्टेट लेजिस्लेचर मे प्रोवाइड. स्टेट लेजिस्लेचर मे फर्स्ट इज ऑथराइज पंचायत to collect taxes first important है state legislature may authorize the panchayat to collect the taxes. They can collect their own taxes like anything like octroi taxes, toll taxes, any tax they can. Second, some of the taxes that is collected by the state and this taxes will be assigned to the panchayats. So collection will be done by the state, but they will be given to the panchayat. That also can be given by the finance. So who will give this? State finance commission will decide basically. So finance में क्या है कि state legislature can decide regarding assigned taxes, duties collected by the state government. First में क्या है कि panchayat they are collecting themselves only. Second, collected by the state government, but they will be given to the panchayat. Just like central state, many of the tax that is collected by the central government, but they are given to the state government. Same यहाँ पे है. Third, state legislature can provide grants from consolidated fund of state. Consolidated fund of state. जैसे consolidated fund of India है, वैसे consolidated fund of state is there. So state legislature can decide that this much of fund can be granted to the panchayat from the consolidated fund of the state. और state legislature क्या कर सकता है? Fourth thing state legislature can do is constitution of consolidated fund for panchayat. See, for the central government, we are having consolidated fund of India. Now the entire money is credited there, and any money is required, you can withdraw from it only. At the state also, we are having consolidated fund of the state, but we are not having any fund in the name consolidated fund of panchayat. Whatever the money is coming, it will go there only, and then from there it will go to withdraw. So state legislature can constitute the consolidated fund for the panchayat. इनमें से state ने कोई काम नहीं किया है. This is the funding issue panchayat face. Now problem is this. Even though if they authorize the panchayat to collect the taxes, panchayat will not be able to collect the taxes properly. Suppose example, you are pradhan and state legislature has given you authority to collect the taxes. Like example, entry tax. Those who are going to enter into your village, they need to pay some 5 rupees, 2 rupees tax. Next time आप प्रधान बन जाओगे? नहीं बन पाओगे. You will become unpopular. Correct or not? So next time, people are not going to elect you as a pradhan. And they are living near to you only. They will beat you. आपके पास कोई सिक्योरिटी है नहीं, सारे गांव मिलके पीटेंगे. ठीक है? Because of that reason is, even though if you provide them to power to collect the taxes, they will not able to collect the taxes because they are living very near to the people. They will become more unpopular. और उनको जीतने से ज्यादा किसका प्रॉब्लम है? रिलेशनशिप का. करेक्ट? कि रिलेशन खराब है, शादी ब्याह में कोई बुलाएगा नहीं उनको, है ना? This is the issue they are facing. Because Kerala government has tried to provide them power to collect the taxes. No panchayat has collected a single rupee. Even panchayat to छोड़ दो. आप for example BBMP का ले लो. BBMP is not able to collect the taxes properly. Property tax, they are not collecting because they will become unpopular. So this is the reason they are having. Right? So ultimately for every funding they are dependent only on two things. ये भी कोई ज्यादा नहीं. Main thing is this provide grants needed for consolidated fund of the state. So grants कहाँ से आता है? Basically two places से आता है. First grant is coming from the consolidated fund of the state, and second grant is coming from consolidated fund of India also. जब हम लोग पढ़ेंगे finance commission, तो finance commission send that grant from the central government. So clear this. और यहाँ पे भी they have mentioned may authorize. क्या है may? May means they will not going to authorize. Simple. So this two provisions, that is power and finance, both comes under category of may, or both are the voluntary feature. So if you want to write a mains answer, you can provide this reform only. In place of may, if you change this term into shall, state legislature shall provide, then this is better for the development of the rural areas or urban areas, because then they will be definitely institution of self-government easily. Because if power and finance is not there, then there is no use of anything then. Clear? Next is, so these two are voluntary features, power and finance, they are voluntary feature. Next is finance commission. So they are also having finance commission, that is called as state finance commission. This is state election commission, same as state finance commission, that is appointed by governor. So they basically review the financial positions of the panchayat and provide necessary recommendations. They review the financial positions of the panchayat and provide necessary steps. Review the financial position of the panchayat and provide necessary steps. Next feature is audit of accounts. Audit of account. Again, state legislature may make provisions for audit. Make provisions for the maintenance and audit of पंचायत अकाउंट. जैसे सीएजी ऑडिट करता है, वैसे इनके ऑडिट के लिए भी बोल दिया है कि यस, स्टेट लेजिस्लेचर कैन प्रोवाइड फॉर द ऑडिट ऑफ द पंचायत अकाउंट. इसी में आता है आपका बेसिकली सोशल ऑडिट. सोशल ऑडिट see, normally audit क्या होता है? Audit means whatever the money that gram panchayat they have spent, that money was allocated or not. Simple. एक चीज देखेंगे whether the money was allocated for that work or not. CAG also check this thing only कि whatever the schemes के लिए you are spending the money, whether money was allocated or not, whether you are having proper approval or not. Simple. That's it. But यहाँ पे they are going to check some more things. For example, social audit में they will check whether money is allocated or not, correct, approval was there or not, and road has been built or not. और built हुआ है उसके बाद भी एक step है, whether there is a need of road or not. रोड चाहिए ही नहीं था फिर भी आपने बना दिया, करेक्ट. वहां एक घर है बस बाबूजी का, उनके लिए पूरा रोड 2 किलोमीटर बना दिया है, करेक्ट है. और जहां चाहिए वहां रोड ही नहीं है, करेक्ट है. यहाँ पे इंटायर बस्ती इज देयर, नो रोड इज देयर. So social audit में they check this thing also whether we need this thing or not. So social audits में who will involve? Gram Sabha members are involved. Correct? So social audit is a constitutional thing or not? It is a constitutional thing because it is mentioned in the constitution. Clear? And next is feature is application to the union territories. Whether this 73rd amendment it will be applicable to the union territory or not. So application to the union territory. UTs. So you have a president will decide. President may direct. So president may direct means which provision should be implemented, which provision should not be implemented. Entire authority is with the President of India only. Clear this? Now some areas which are exempted actually. Exempted areas जहाँ पे this will not be applicable, this 73rd amendment will not be applicable. Nagaland, Meghalaya and Mizoram. So act does not apply in the states of Nagaland, Meghalaya and Mizoram. And certain other areas, basically those areas which are 5th schedule areas and 6th schedule areas. And any other certain areas, because in those areas we are having 5th schedule and 6th schedule. इनके लिए different system we are having. Like in 5th schedule we are having different, जिसको बोलते हैं PESA, PISA Act, पंचायती राज extension to the schedule area. Panchayati Raj extension to the schedule area act is there. So this will not be applicable to this area. PISA Act, Panchayati Raj extension to the schedule area. So this act will not be applicable in Nagaland, Meghalaya and Mizoram, in certain other areas. Which are those other areas? 5th schedule areas and 6th schedule areas. 5th schedule areas in the mainland India, especially 10 different states are there, and 6th schedule areas are in 4 states. Clear? Next is bar to interference by the court. Court cannot interfere here. Enter by court. So this is applicable for every election, not in panchayat, even state also, even central also. The court cannot interfere in these elections. उसके लिए आपको क्या करना पड़ेगा? You have to file election petition. So who will file election petitions? Those who are involved in that election. Like you are contesting the elections, आपको लगता है कि money was involved in that elections, some fraud happened, then you can file an election petition, then only court can interfere. Court cannot interfere in suo motu basis here. Same for this panchayat elections also, bar to interference by the court. Clear हुआ अभी? अब हम लोग एक साथ पढ़ लेंगे compulsory provisions and voluntary provisions. कौन कौन से थे? So first is compulsory provisions. Compulsory provisions means those provisions which are same for every state. This is important for UPSC. You will ask which of the following they fall under compulsory provisions of the 73rd amendment. First provision is organization of Gram Sabha. Organization of Gram Sabha. Gram Sabha should meet 2 times in 1 year always. Gram Sabha should meet 2 times in 1 year. 6 months, 6 months. ये आपको केस स्टडी में पूछा जाएगा एथिक्स में रिगार्डिंग ग्राम सभा प्रॉब्लम्स एंड पंचायत सेक्रेटरी प्रॉब्लम्स. क्योंकि ग्राम सभा इवन मीट भी करता तो कोई दे आर नॉट एबल टू ब्रिंग एनी फ्रूटफुल डिस्कशन, क्योंकि सबसे पहले उनके दे आर नॉट हैविंग एनी एजेंडा. पंचायत सेक्रेटरी नॉट डिस्ट्रीब्यूट दैट एजेंडा. उसके बाद क्या है, पीपल दे आर इन्वॉल्व इन द फार्मिंग और इन अदर वर्क, और किसी तरह आपने इकट्ठा कर भी लिया ना, देन दे स्टार्ट फाइटिंग फॉर पर्सनल इश्यूज. आपकी बहस हमारे खेत में क्या कर रही थी बताओ, तो पर्सनल लड़ाई हो गया, झगड़ा हो गया. So that is the reason is they are not meeting regularly. So this is the first. Second is creation of 3-tier system. This is another creation of 3-tier system or structure. 3-tier structure लिख लो. So that is same for every stage. Third, all the seats in panchayat should be filled with direct elections. तो जो भी सीट्स थी आपने देखा था मेंबर्स की, they were direct elections only. चेयरमैन फॉर पंचायत समिति एंड जिला परिषद in direct elections. In direct elections. This is also compulsory. Minimum age 21, compulsory everywhere. Reservation for SC, ST and women. It is also compulsory for every state. Tenure 5 years, compulsory. Then 6, State Election Commission plus State Finance Commission every 5 years. This is also compulsory. Every state should have a State Election Commission and a State Finance Commission every 5 years. Clear this? So this thing already we have covered. Now comes to voluntary provisions. They will change state to state. Our state legislature have complete authority regarding that. Voluntary provisions. Right? Voluntary provisions. First is giving voting rights to MLA and MP. Whether जो जिला पंचायत की मीटिंग्स हैं, पर जिला पंचायत समिति मीटिंग्स हैं, in these meetings MLA or MP can be given voting rights. Who will decide? The state legislature will decide. Second is providing reservation to backward class. Providing reservation to the backward class. It is also voluntary provisions. Like recently, Uttar Pradesh has given this reservation to the backward class. Third is financial autonomy. It is also voluntary provision. Devolution of power and functions. अभी पढ़े थे power and functions. It is also a voluntary only. Done. So these are the provisions which are voluntary in nature. They will be changed from state to state. So maximum provisions are basically compulsory only. But जो सबसे important provisions हैं ये 2 provisions. They should be compulsory, but they are became the voluntary provisions. Clear this? Okay, so that's it. Tomorrow हम लोग next class में 74th amendment, that is municipalities.